Guardianship in Indiana. Hello, I'm Melissa Keys from Indiana Disability Rights, and in this video, I'm going to answer some common questions about guardianship in Indiana. What is guardianship? Simply put, guardianship is when a court appoints someone to make decisions for a person who is unable to make decisions themselves. Are there different types of guardianship? Guardianship is not a one-size-fits-all solution, so there are different types of guardianship that should be explored to determine what would be the best fit based on the person's needs. There are temporary guardianships, which last for a certain period of time, and there are limited guardianships that are generally over the person or the estate. Guardianship over the person often covers medical care, where they live, and general day-to-day functioning. Guardianship over the estate may cover the person's property, assets, or finances. There's also full or plenary guardianship, where all decisions are made by the guardian. When is guardianship appropriate? Guardianship may be appropriate if someone is unable to make or communicate decisions about their life, keeping in mind that not all communication is verbal. In Indiana, guardianship is not required to access services, supports, or entitlements. When appropriate, there are less restrictive ways to help someone with decision-making or to participate in their care. To learn more, watch our video titled Options for Supporting Independence in Adulthood. How is guardianship established? First, a petition must be filed with the court. The petition must meet the legal requirements set forth in Indiana Code. This includes a statement about whether less restrictive alternatives to guardianship have been considered or tried prior to seeking guardianship. The petition may also include a physician's statement attesting to the individual's functional limitations and decision-making abilities. At this time, the judge may appoint a guardian ad litem to make recommendations to the court about whether the person needs a guardian and if the petitioner or proposed guardian is appropriate. Next, there will be a hearing where the person, the proposed guardian, and perhaps those who have an interest in the guardianship will have an opportunity to make their case to the court. Following the hearing, the court will make a ruling that will either grant, deny, or stay the petition. If the petition is granted, a guardian will be appointed and letters of guardianship will be issued. Because all guardianships are established through the courts, people are encouraged to consult with an attorney knowledgeable about the process. What decisions are guardians allowed to make for the protected person? Unless limited by the court, the guardian may enter into contracts on behalf of the protected person, give consent to their medical care, make the decision of where and with whom they may live, manage their finances, and decide whether or not they can marry. What are the responsibilities of the guardian? The letters of guardianship spell out the scope and responsibilities for the guardian. Guardians are also expected to comply with Indiana law. Additionally, the guardian should encourage the person's participation in decision-making to the greatest extent possible. Can a person under guardianship vote? Yes. In Indiana, a person under guardianship still has the right to vote. Can a guardianship be changed or terminated? Yes. A guardianship may be changed or terminated with court approval. Some changes to the guardianship could include the adding, removing, or changing of guardians, or changing the scope of the guardianship. The guardianship will end when the protected person dies. Guardianship does not end if the guardian resigns or dies. If that happens, the court will appoint a new guardian. A guardianship may also be terminated by showing the court that a person no longer needs a guardian. For more information, visit our website at www.indianadisabilityrights.org. We're here to help.